the United States bond and saying nothing further than he has already said. And the court being now well advised in the premises, it is therefore considered, ordered, adjudged, and sentenced that the said defendant, James Wilson, do pay to the United States a fine of $5,000, and that the United States have execution therefore, and that he be imprisoned for and during the term of 15 years at hard labor in the House of Correction at Michigan. If you notice this, here's a judge says, notice up there at the very top, do you have anything to say why the judgment and sentence of the court should not now be pronounced? They do that right here in Ada County, Idaho. Do you know of any lawful reason why I cannot impose sentence upon you now, Mr. Gordon? Well, yes, sir, Your Honor. I'm glad you raised that question because I can think of 5 reasons why you should not and cannot pass sentence upon me for any cause or reason. And that's what this guy Wilson should have done. Yes, Your Honor, I can think of a couple of reasons. One, you've proceeded against me by information without a grand jury indictment, and therefore I'm moving for a directed verdict of acquittal and dismissal of the charges. And you ought now at this time to dismiss this case and release me. But I guess this fellow probably didn't know and understand that. The petitioner down at the bottom of the page here alleged in his petition and contended in argument that his imprisonment was illegal upon the following grounds. Okay? Here's why when he filed his appeal or his petition. I guess this is a petition for writ of habeas corpus. First, that in excess of the power of the court and in violation of the Fifth Amendment of the Constitution, he had been held to answer for an infamous crime and punished by a fine of $5,000 and imprisoned for a term of 15 years at hard labor without presentment or indictment of a grand jury. There's his appealable issue. Second, that he was held under a judgment void and in excess of the power of the court. In other words, he's saying the court doesn't have any jurisdiction in this matter for this reason. Upon an information for a crime which was not committed against the provisions of Chapter 7 of the title Crimes in the Revised Statutes, in which case those informations were expressly authorized and to which they were impliedly restricted. Third, that the judgment was void and in excess of the power of the court because the conviction and the sentence were for different offenses, the conviction being for having in possession a bond of a mining company in the similitude of a United States bond, and the sentence being for passing a counterfeit United States bond. Fourth, that he was held by the keeper of the Detroit House of Correction without authority of law because the order of the court for his imprisonment did not show that the court had determined 2 questions of fact which were made by revised statute so-and-so. Okay. The court is only going to decide upon 2 questions here. The question of the information and the grand jury. Mr. Justice Gray did this one again. I guess Gray did both of these. Now I want to read here on page 421, I'm going to show you that they're going to go, you ever notice when you read a Supreme Court case that they cite a lot of prior cases? No different here. Here's 1883 or 4. This is before the Mackin case. No difference. Here's your court going into prior cases. Mr. Justice Gray, I'm going to have to start on page 420, after stating the facts in the foregoing language, delivered the opinion of the court. It is well settled, notice the words well settled, by a series of decisions that this court, having no jurisdiction of criminal cases by writ of error or appeal, cannot discharge on habeas corpus a person imprisoned under the sentence of a circuit or district court in a criminal case, unless the sentence exceeds the jurisdiction of that court or there is no authority to hold him under the sentence. Okay? I want you to understand this. When you file a writ of habeas corpus, you've got to be alleging the jurisdictional defect. The jurisdictional defect comes into play whenever you've been convicted and there has been a constitutional violation. For instance, if you were denied counsel during the trial or any meaningful hearing prior to trial, the court of its own volition has denied itself jurisdiction, because it's a jurisdictional defect anytime a constitutional right is involved, because there can be no rulemaking or legislation that would abrogate a right. That's Miranda, page 491. So anytime a right is involved, we're talking about common law, aren't we? We're not talking about civil law. We're talking about common law rights. And whenever a common law right is violated, that's a constitutional right, the court thereby voids the conviction of its own volition because it had no jurisdiction. So when you bring the issue forward, it comes under a writ of habeas corpus. So you move it up on a writ of habeas corpus and say, wait a minute, that patent court sentenced me to prison for murder. The patent court had no jurisdiction to try a murder case. I told them so. I wrote a motion and I said, this is the patent court, there's no jurisdiction here, and they wouldn't listen to me. Now, if prior to trial you put that motion in and you put it in timely, boy, you're on solid ground. Now, if you didn't put that motion in prior to trial, because it's a jurisdictional defect, you're still on solid ground because you can always appeal or always call into question a jurisdictional defect even after you've been in prison for 25 years. You can't appeal because your appeal time's out. So if you're in prison and your appeal time is out, motion it up on a writ of habeas corpus and then present the jurisdictional defect and move the court to vacate the jury conviction. That's what you just saw here, and we'll see that in numerous other cases. I just thought I'd point that out to you since we just read it here on 421 of this Ex parte Wilson, that the vehicle that you use when you go into court is the writ of habeas corpus. You know, if you go in there on a writ of error, they're not going to listen to you. If you go in there on some other kind of a motion, they won't listen to you. Jurisdiction, that's the one you want to use, and the habeas corpus. All right, going on then, none of the grounds on which the petitioner relies except the first requisite extended or require extended discussion. So, remember in Lesson 13 I gave you those 7 rules that the court's going to go by, didn't I? All right, and so here's the court saying, well, we don't need to talk about all this other diatribe. We've decided we're going to rule in this guy's favor, and we only need to rule on one issue, and that's the only issue we're going to pick out. And it's the issue of the grand jury. So going on here, I'm going to skip over a few pages, over to page 423. Let's take a look at 423, about halfway down where it's underlined. By the law of England, informations by the Attorney General without the intervention of a grand jury were not allowed for capital crimes, nor for any felony, by which was understood any offense which at common law occasioned a total forfeiture of the offender's lands or goods or both. That comes from Blackstone 4th, page 94-95, and 310. The question whether the prosecution must be by indictment or might be by information thus depended upon the consequences to the convict himself. Notice the words, might be by information. So if you're going to be sentenced to jail for a year or less, it might be by information, depending upon your state. Or in a federal case, it might be by information if it's a misdemeanor and they're going to sentence you to jail for a year. No grand jury need be brought in. Page 424. Mr. Dane, one of the most learned lawyers of his time, and who, as a member of the Continental Congress, took a principal part in framing the ordinance of 1787 for the government of the Northwest Territory, assumes it as unquestionable that by virtue of the amendment of the Constitution, informations cannot be used where either capital or infamous punishment is inflicted. Infamous punishment is a year and a day. Judge Cooley has expressed a similar opinion, Cooley's principle of constitutional law. Now, Black and Cooley are practically like quoting from Thus saith the Eternal. Whenever you're quoting from Scripture, it's Thus saith God. Whenever you're quoting law, it's Thus saith Cooley or Blackstone. So those are a couple of good citations. Page 426, let's read on a little more about these grand juries and informations. The question is whether the crime, I'm on page 426 now, follow along. The question is whether the crime is one for which the statutes authorize the court to award an infamous punishment, not whether the punishment ultimately awarded is an infamous one. When the statute says 2 years in prison, let's start screaming grand jury. When the accused is in danger of being subjected to an infamous punishment if convicted, he has the right to insist that he shall not be put upon his trial except on the accusation of the grand jury. And in Idaho, we're entitled to grand juries. And I'll show you how that comes down in a little bit later. But not every state is. And in those states where you're not, you better be screaming to your legislatures and let's start getting that turned around. Because you people that are being prosecuted by informations in those states that do not allow in your state constitutions grand juries, you're being put upon your trials by the government. Nor can we accede to the proposition, which has been sometimes maintained, that no crime is infamous within the meaning of the Fifth Amendment. That has not been so declared by Congress. And here's 2 or 3 citations to cover that. The purpose of the amendment was to limit the powers of the legislature as well as of the prosecuting officers of the United States. And boy, there's a powerful statement from your Supreme Court. The purpose of the amendment, that is, that Fifth Amendment, was to limit the powers of the legislature and prosecuting attorneys and public prosecutors. And that's why we have grand juries, to limit the power of your Ada County Prosecutor's Office. We don't want trial by government, except when we waive our rights. When you want a trial by government, I'll let you know. Otherwise, it's always trial by jury. Trial by the grand jury. I want my grand jury in here. We are not indeed disposed to deny that a crime to the conviction and punishment of which Congress has superadded a disqualification to hold office is thereby made infamous. But the Constitution, protecting everyone from being prosecuted without the intervention of a grand jury, got that? The purpose is to protect you from being prosecuted by anything other than a grand jury. For any crime which is subject by law to an infamous punishment, no declaration of Congress is needed to secure or competent to defeat that constitutional safeguard. All right? Those are some powerful words by our Supreme Court. On page 428, for more than a century, imprisonment at hard labor in the state prison or penitentiary or other similar institution has been considered an infamous punishment in England and in America. And again, whether we consider the words infamous punishment in their popular meaning or as they are understood by the Constitution and laws, a sentence to the state prison for any term of time must be considered as falling within them. Besides, the state prison for any term of time is now by law substituted for all of the ignominious punishments that were formerly in use, and unless this infamous, then there is now no infamous punishment other than capital. So he's simply saying, if this isn't infamous, then there is no such thing as infamous crime other than capital. Deciding nothing beyond that is required by the facts of the case before us. Our judgment is that a crime punishable by imprisonment for a term of years at hard labor is an infamous crime within the meaning of the Fifth Amendment of the Constitution, and that the district court, in holding the petitioner to answer for such a crime and sentencing him to such imprisonment without indictment or presentment by a grand jury, exceeded its jurisdiction, and he is therefore entitled to be discharged. So turn that counterfeiter loose. And I'll just bet you that there were just screams and howls, in the press. The commie pinko fags have done it again, turning counterfeiters loose on the streets to victimize us again and again. And the truth of the matter is, it's because of an incompetent judge and an incompetent court and incompetent prosecutors who simply didn't want to waste time obeying the law and taking this joker to a grand jury. If they'd have taken him to a grand jury, don't you suppose that the grand jury would have issued the indictment? And it's no different today than it was then. They've sent forth swarms of officers to eat out our substance. And these same swarms of officers who are eating out our substance, the moment you say to them, no, this far and no further, will then go to their own courts and to their own prosecutors and single you out. And then the government, with all of its vast array of power, resources, and money, singles you out and hauls you into their court and prosecutes you by information. And you'll probably sit there and say, well, I plead not guilty, Your Honor. I plead not guilty. I'm going to show you a jurisdictional defect, and I'll show you how to do a little more than plead not guilty. I'll show you how to sit there and say, what do you mean bringing me into this government court? Where's the grand jury? There's 8 jurisdictional defects on the face of this information. And let's listen to a little word from Blackstone. Listen to this. An information is a written accusation of a crime. It's made by a U.S. attorney which permits the government to prosecute an individual without benefit of a grand jury. The Supreme Court had clearly ruled in Macon v. U.S. 117 U.S. 348 and Wilson v. U.S. 114 U.S. 417. We just covered those. That any crime for which the punishment is imprisonment is an infamous crime. And the use of informations has a long history. For example, in the reign of Henry VII, writes Justice Blackstone. Now remember, he's as good as God when it comes to law. In Blackstone 4, commentary page 310, a very oppressive use was made of them for something more than a century, so as to continually harass the subject and shamefully enrich the crown. Well, what do you think they're doing today by sending out these swarms of officers, charging us with informations, subjecting us to government trials, finding us guilty, and then putting us in jail pursuant to the law enforcement growth industry? You know, those jerks have got a business going in this country called law enforcement. And it's a growth industry that makes McDonald's look like pikers. So here's a very oppressive use made of them. Also, as the court observed in People v. Spunzler, 46 Northwest 450, the oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality. In short, prosecutions by information have long been a means of political suppression and intimidation. Informations go to the grand jury. The grand jury puts out the indictment or the presentment. And that's the way that has to come down. That's legal quotation number 80. Now let me go on here, talking about informations. I've got a brief here. I didn't realize how long-winded I was until I pulled this brief out. It's about 10 pages. On informations. Now, we've covered this in previous, the subject matter of grand juries and informations, and presentments and prosecuting attorneys, etc. And I want to make sure that you get this information. So this is a notice and demand to dismiss for want of jurisdiction. And then I'm also going to send in this lesson here a notice of jurisdictional defect and constitutional objections, demand of due process rights. This is 8 jurisdictional defects. I want to send that in this lesson. If I didn't get it in earlier lessons, it's time. This is a fairly brand new case. I've just been charged with a felony here about, I don't know, January or February. My government doesn't like me. They want to put me in the penitentiary out here. Boy, wait till we start writing writs of habeas corpus from the Idaho State Pen. Nevertheless, this notice of jurisdictional defect I filed in about, I don't know, March, April, or May of 1983. So if I don't have it in the earlier lessons, it's time that you saw this information. And that'll tell you some more about grand juries. And if you get this born-again republic, now you're going to start to see what Red Beckman has been doing up in Montana and how that grand jury is absolutely necessary and imperative for every citizen in this country. Our Republican form of government just plainly cannot work without it. And we're either going to get them back or we're going to continue to be slaves, which is about where we were in 1775. So I'd say our condition today isn't much different than it was then. All right, now the next thing I want to bring up, let's start taking a look at some jury cases concerning, now let's move on here to the petite jury. I want just to give you a little introduction. A petite jury is simply the trial jury, nothing more, nothing less. So here you have a 16-man jury. That's your grand jury. And then you have the trial jury, which is the petite jury. And the very word jury means 12. I didn't make it that way. I got here in 1939. So I don't want any of you people out there, if you're a judge and you've been to law school or you're a lawyer and you know more than I do, don't get mad at me because I didn't say that. I'm just going by what the Supreme Court of the United States and Supreme Courts all around the United States have been saying about it since Magna Carta in 1215. They've been telling me these crazy, bizarre, wild, off-the-wall doctrines and I'm just repeating them because I think they know what they're talking about. These guys like Black and Cooley, or Blackstone rather, and Cooley, and Learned Hand, and John Jay, and Marshall, and Warren. You know, these judges have been saying this for years, and these old dust-covered, leather-bound volumes have got this information in them. It's just that we haven't been using our common law for something like 75 to 100 years, and we've made this shift from status to contract, and so here we are under the Roman civil law being compelled to volunteer. Can you imagine that? Volunteer to pay income tax. Volunteer to go into these traffic courts with our driver's licenses, and volunteer to go into magistrate and district courts and to waive our rights to grand juries. What do we need a grand jury for? Everybody's licensed, bonded, and insured, aren't they? And so with the licensing, the bonding, and the insuring, we don't need courts and juries and grand juries. All we need is an administrator to just sit there and administer the penalties for the breach of contracts. And that's all they really do. Our judges are simply administrating breach of contract. The very first case that comes out of this this jury book, it's called Jury Cases, is called Georgia versus Brailsford. So let's start in 1794 and see what John Jay had to say about a jury. It's on page 72. This case is identified as 3 U.S. 1. So if you're looking in the U.S. Supreme Court reports, it's actually 3D1. That's called Dallas. And the U.S. Supreme Court now has the same numbering system that it begins with Volume 1. And this will be in the very first book in that section called U.S. Supreme Court Reports. The case was decided in 1794 in the February term. The ink is barely dry on our Constitution. And the Supreme Court of the United States, John Jay, the Chief Justice, is going to give the opinion. It's over here on page 72, I believe. Yeah, about page 72. And it says here, "It may not be amiss here, gentlemen, to remind you of the good old rule that on questions of fact, it is the province of the jury. On questions of law, it is the province of the court to decide. But it must be observed that by the same law which recognizes this reasonable distribution of jurisdiction, you have nevertheless a right to take upon yourselves to judge both and to determine the law as well as the fact in controversy. On this and on every other occasion, however, we have no doubt you will pay that respect which is due to the opinion of the court. For as on the one hand it is presumed that the juries are the best judges of fact, it is on the other hand presumable that the court are the best judges of law. But still, both objects are lawfully within your power of decision." Now, I didn't write that. So any of you lawyers or judges out there that are just up in arms here, let me remind you that when we had our common law, the jury decided the law and the fact. And some jerk lawyer the other day said, well, no, it wasn't a lawyer, I'll take that back. I don't want to be rude to you fellas. It was an IRS agent. He said, well, what we go by now is the modern law. Isn't that what King George was saying in 1775? Well, we've got the modern law. And we send out these officers to harass you and to eat out your substance because this is the modern law. To which I say, to hell with the modern law. Now let's flip over here and take a couple of 3 citations as we go along from some other nifty cases. Let's try the next case in this book, which is called Thompson versus Utah. Skips ahead to 1899. We're talking about juries, petite juries, common law juries, the jury of 12. Those jurors who sit there as the judges. Okay? Now we'll take a look at this thing of law and fact and when it was changed, which was about 1850, and we'll take a look at Roscoe Pound and a few other nifty lines that come from some of our older law schools and older law professors. By looking at Thompson versus Utah, here's a fellow who stole a calf, and he's got 2 or 3 trials that come up here. You need to read the whole case here so that you can grasp it and get a good feeling, for the subject matter. But let's take a look at what the case is about, and then let's take a look at what the case says by dicta. Because this case is not a case on juries. It's reputed to be a case on juries, but it's really a case on ex post facto laws, what its subject matter is. And by dicta, it simply says that a jury is 12, no more and no less. This was delivered by Justice Harlan, and it's by an indictment returned in the District Court of the 2nd Judicial District of the Territory of Utah at its May term of 1895. The case was first tried, I'm going to skip along here as I go along. I'm on page 344. This is your opening page here called The Opinion of the Court. The case was first tried when Utah was a territory, and by a jury composed of 12 persons. Both of the defendants were found guilty as charged and were recommended to the mercy of the court. A new trial having been granted, the case was removed for trial to another county. But it was not again tried until after the admission of Utah into the Union as a state. At the second trial, the defendant was found guilty. He moved for a new trial upon the ground that, among others, the jury that tried him was composed of only 8 jurors. You know, that's strange. You know, Utah, which is the bastion of the Mormon church, which is the, probably, if that church isn't it is close to the number one arbiter and protector and advocate of the Constitution of the United States, and for that state to reduce a jury to 8 members is inconceivable. But here it is, there's Utah, 8 jurors. Whereas by the law enforced at the time of the commission of the alleged offense was a lawful jury in this case and could not be composed of less than 12 jurors. And so here's your Supreme Court says a lawful jury of 12. Or what do you suppose they thought of an 8-man jury? Could it be that it was an unlawful jury of 8? You know, what isn't said can oftentimes be more eloquent than what is said. Whereas by the law enforced at the time of the commission of the alleged offense, a lawful jury, in this case, could not be composed of less than 12 juries. The application for a new trial having been overruled and the accused having been called for sentence, he renewed his objection to the composition of the jury, and he moved by counsel that the verdict be set aside and another trial ordered. This objection was overruled, and the accused duly accepting to the action of the court, he was then sentenced to the state prison for the term of 3 years. The judgment of conviction was approved by the Supreme Court of Utah, the court holding that the trial of the accused by a jury composed of 8 persons was consistent with the Constitution of the United States. So the Supreme Court of Utah in 1895 to 1900 took a look at this guy's petition and said, yeah, a jury of 8 is perfectly constitutional. If they'd have done that in Texas, I think we'd have understood it. To do that in Utah is incomprehensible to me. By the statutes of the Territory of Utah in force at the time of the commission of the alleged offense, it was provided that a trial by jury in a district court should consist of 12, and in the justice court of 6 persons. Boy, are we going to see some revelations here in a moment. Unless the parties to the action or proceeding in other than criminal cases agreed upon a less number. Here's a criminal case being tried then in a civil form. You know, to this day, if you want to agree to something less than that in a civil case, that's all right. And I don't have a problem with that. But I can show you some cases out of this book here to tell you that even the defendant cannot have an 11-man jury. So going on down at the bottom of page 345, by the Constitution of the State of Utah, it is provided in capital cases the right of a trial by jury shall remain inviolate. Right of a trial by jury. In courts of general jurisdiction, except in capital cases, a jury shall consist of 8. Oh, we're going to have 8, 12, and 6. All right, now let's skip over a couple pages. I'll let you read this. The issue now becomes ex post facto. There's your introduction. Turn over here to page 349, and let's take a look then at what the Supreme Court has to say when they get to a more scathing indictment of the Supreme Court of Utah. Down at the bottom of the page where it says, assuming then that the provisions of the Constitution relating to trials for crimes and to criminal prosecutions apply to the territories of the United States, the next inquiry is whether the jury referred to in the original Constitution and in the Sixth Amendment is a jury constituted as it was at common law of 12 persons, neither more nor less. A jury at the common law at the formation of the Constitution is a trial or is a jury of 12, neither more nor less. This question must be answered in the affirmative. When Magna Carta declared that no free man should be deprived of life, etc., but by the judgment of his peers or by the law of the land, it referred to a trial by 12 jurors. Magna Carta. Trial by 12 jurors. Got that? Not 8, not 6, not 11, not 29, 12. 12 is the magic number. Those who immigrated to this country from England brought with them this great privilege as their birthright and inheritance as a part of that admirable common law which had fenced around and interposed barriers on every side against the approaches of arbitrary power. They should have used the word arbitrary tyranny by government. In Bacon's abridgment, trial juries, it is said, the trial per pie, or by a jury of one's country, is justly esteemed one of the principal excellencies of our Constitution. For what greater security can any person have in his life, liberty, or estate than to be sure of not being divested of or injured in any of these without the sentence and verdict of 12 honest and impartial men of his neighborhood? And hence we find the common law herein confirmed by Magna Carta. Wait till we get to Williams versus Florida and a couple of other more recent off-the-wall cases where our federal Supreme Court, in my view, has really led us down the primrose path. Now, occasionally the High Court makes an error, but I'll explain that. It could well be that in the Williams case, as many of you out there may know, which upheld the 6-man jury in a felony case in Florida, may have been this. Mr. Williams asked the question, does a 6-man jury violate my right to due process under the 14th Amendment? And the High Court said no. I contend that he asked the wrong question, because I think he was tried by statute, and I don't think he raised the question timely. And the courts have said consistently that the issue of the jury is not a due process issue. Well, if it's not a due process issue, then what kind of an issue is it? And that's the question that you've got to ask and raise prior to trial in your motions. So when we're talking about juries and we want to raise that jury issue as a major federal question, then the 12-man jury without question is a 12-man jury. And I'm going to show you here in a moment when we get into words and phrases that the very word jury means 12. Well, then, when we get to the end of this volume and we investigate the Williams case, which I'll do a little later, we're going to find that I think Williams asked the wrong question, and therefore he got the right answer to the wrong question, which sent the wrong message to every court in the land. Until now, they think that a 6-man jury can interpose for a common law jury. And I contend that's error. The 6-man jury is an administrative process under code. And any time the civil law gives you a 6-man jury, an 8-man jury, a 2-man jury, they're just putting frosting on your cake because they don't need to even give you that. Going on then on this page, it says the supreme law of the land required that he should be tried by a jury composed of not less than 12 persons. This court doesn't have any doubt as to what a jury is. Unfortunately, Thompson is dicta. Remember that? You've got dicta here because the issue in this case is ex post facto law, so you can't use this case as a jury issue. And when White wrote that case in Williams, he referred to Thompson over and over again and said they hadn't reviewed the issue competently. And he ridiculed and impugned the founding fathers clear back to Magna Carta. I think he did err in his opinion. And if he didn't err, then It's about time that we, the citizens, got into the courts and said, it's time that we told you you erred. Now reverse yourself. And the way we're going to get that done is by moving some cases into the higher courts. Now, let's see. Let's flip over here to page 352. The legislature may abolish courts and create new ones, and it may prescribe altogether different modes of procedure in its discretion, though it cannot lawfully, we think, in so doing, dispense with any of those substantial protections with which the existing law surrounds the person accused of crime. And there you are. Now that's exactly what many states have done, Florida being one of them. They've taken our 12-man jury, it would appear, and reduced it to 6, done it by constitutional enactment in their states, and the Supreme Court of the United States does not want to interfere in that determination. Now here in Idaho we haven't done that, at least not to the extent that they have in Florida. I contend that a jury is 12 and that a jury, whether it's a parking ticket or it's murder, has got to be convened, and you've got to have a grand jury. And if we don't have that, then we've got trial by government. And if we're going to have trial by government, we are going to have tyranny, because it's the jury that protects us from that government. And anytime we get trial by government, friends, we've got problems. On page 353, if in respect to felonies committed in Utah while it was a territory, it was competent for the state to prescribe a jury of 8 persons, it could just as well have prescribed a jury of 4 or 2, or perhaps have dispensed altogether with a jury and provided for a trial before a single judge. And that's exactly where we're headed. Someone told me recently they have juries of 4 down in Utah. If they can have juries of 4, they can have juries of 2 and juries of none. No, you can't have a jury unless you've got 12, because that's what it means. 353, bottom of the page. It said that the accused did not object until after verdict to a trial jury composed of 8 persons, and therefore he should not be heard to say that this trial by such a jury was a violation of his constitutional rights. I underline that because it illustrates a fact. If, in fact, he failed to make his objection prior to trial, he waived his right to object. So you see how valuable Lesson 13 and 14 is? You'll have your jury objection in by motion and your demand for a 12-man jury prior to going forward in the trial. Could well be that Williams failed to do that down in Florida also. I don't have a transcript of the Williams case. All we have is the opinion of the Supreme Court, and it was a long one, too. Page 354, the argument to the contrary necessarily proceeds upon the ground that he alone is concerned as to the mode by which he may be deprived of his life or liberty, and that the chief object of the prosecution is to punish him for the crime charged. And that which the law makes essential in proceedings involving the deprivation of life or liberty cannot be dispensed with or affected by the consent of the accused, much less by his mere failure, when on trial and in custody, to object to unauthorized methods. The great end of punishment is not the expiation or atonement of the offense committed, but the preservation of future offenses, or the prevention, rather, of future offenses of the same kind. They're saying in here that this guy couldn't even waive that right, that it was up to the court to provide that type of trial, and I would agree with that. Now I've turned over here to the word juror in words and phrases. Flip over here with me, and let's run through some of these samples on words and phrases. And I'm going to show you dozens and dozens of cases. I can't even begin to scratch the surface here of the cases that talk about how many people, 12, what a jury is, how it works, and why. So follow along. Page 231, juror. And it's under, well, if it's in your book, it should be words and phrases on jury. The term jurors means nothing more than 12 men qualified and sworn to try a cause according to the evidence. Fife versus Commonwealth, 29 Pennsylvania, 4 KC 429. Now I'm going to dispense with the citations. You can see the citations as well as I can. Here's grand juror. The term juryman, as used in a statute which renders county officers ineligible as jurymen in any civil or criminal case, is not limited to the members of the petite jury, but extends to members of the grand jury. State versus Graham. Officer distinguished. A juror is one of a body of 12 men. 234 is the page number. His position is to a certain extent a place of public trust and emulant. People versus Hopps. In general, page 235, in the absence of qualifications, the word jury means a jury of 12. A jury implies 12 competent and disinterested men. The contention that the word jury has always meant 12 voters is not warranted by the statutes fixing the qualifications of jurors. So jurors aren't 12 voters. They can be 12 free men, 12 something else. A jury is a body of men composed of the peers or equals of the person whose rights it is selected or summoned to determine. You go to a traffic case. You don't have a driver's license. And you've got 6 slaves over there with driver's licenses. Are they your peers? Are they your equals? Are you a citizen, an individual under the Hale Doctrine, or are you a corporation, a subject, or a member?